Welcome everybody to the Landmark Chambers webinar, which is a planning law update for local authorities on technical issues that particularly relate to planning authorities. We're delighted to see so many of you joining the session today, and we hope that you'll find the presentations and discussions to be useful and informative. My name is Andrew Byass. I'll be chairing the session today. I'm joined by my colleagues Matthew Dale-Harris, Ben Fullbrook and Joel Semakula, who are your speakers today. To begin with, just some few standard matters of housekeeping which I need to mention. First of all, your microphones are automatically muted, so you will not need to adjust your local settings. We very much welcome questions throughout the session. There's a Q&A tab on the webinar, so please submit your questions via text in the Q&A section, which can be found at the top or bottom of your screen. We will endeavour to answer as many questions as possible at the end of the presentations. Don't worry if you get distracted. The webinar will be recorded and you'll receive a link to the presentations and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, fear not, you can rejoin the meeting just by clicking on the original link. So if we can begin then, and I'll do so by introducing the first of today's speakers, and that's Ben Fullbrook. Ben was called to the bar in 2016 after a career in the civil service. He practices in planning and public law and has acted on behalf of developers, local planning authorities and developers. He frequently appears in High Court hearings and at planning inquiries and hearings, and Ben is in the process of writing a book on the General Permitted Development Order, which is due to be published in the summer of this year, which I'm sure will be very helpful reading for us all. I'll hand you over to Ben.
Hi, welcome. Thanks very much for that, Andrew. So yes, I'm going to speak to you briefly about some recent case law on permitted development rights, which raises quite a number of different technical issues. And I'll just start running through them. They're slightly ordered in a slightly random way, but it's just following some of the recent developments. There are a few cases about the issue of prior approval. Prior approval is something I think that's probably coming to increased prominence. As I'm sure all of you are aware, the government has significantly extended and plans to extend even further permitted development rights in various contexts, and almost all of those additional rights are subject to prior approval conditions. So, indeed requiring prior approval on a whole range of matters, about adequate daylight, local amenity, transport, and then perhaps more standard ones like location and siting. So prior approval is probably going to be an increasingly prevalent issue, and actually there are a few unresolved legal matters about prior approval. Probably the main one is what the local planning authority can or should consider when dealing with an application for prior approval. Now, until recently, the understanding was that local planning authorities could only consider those matters which are specified in the order. So in the conditions to the various rights, there are certain matters specified which must be considered for prior approval. I've already set out some of those, so location, siting, things like that. But they can't consider broader questions such as whether the development proposed actually falls within the relevant permitted development right. Now, the understanding on that came from a case called Keenan and Woking Borough Council Court of Appeal judgment. Now, on the facts of that case, what was happening there was that the developer had obtained prior approval from the local planning authority, or hadn't obtained prior approval in time. But in any event, he'd fulfilled the prior approval condition, and he sought to argue that as a result, he effectively benefited from planning permission. He was entitled to carry out his development, even though it clearly fell outside of the relevant permitted development right. What the Court of Appeal really said in that case was that that was wrong, because a grant of prior approval isn't a grant of planning permission, and a local planning authority cannot, by granting prior approval or by not determining a prior approval application, can't modify or extend the general permitted development order. But what Lord Justice Lindblom said in that case, one of the things he said was on an application to an authority for a determination as to whether its prior approval is required, then the authority is bound to consider and determine whether I'm reading from the wrong judgment, I think, there actually. But yes, what he said was that the local planning authority does not have the power under the provisions for conditions in either of these two classes to vary the terms of the permitted development rights within the relevant class. Those provisions do not empower an authority to consider whether the permission should be granted for development which is not of the specified type and description. Now, that judgment was then taken up by Mrs. Justice Lang in a case called Marshall in East Dorset District Council. And she understood that to mean as follows. So this is what she said. It was confirmed in Keenan that the prior approval conditions do not even come into play unless the proposed development falls squarely within the description of permitted development in the relevant class. However, Keenan also decided that the local planning authority, when deciding a prior approval application under the terms of the GPDO, is not empowered, either expressly or implicitly, to decide whether or not the proposed development comes within the description of the relevant class in the GPDO. So that was the sort of prevailing position, that when a local planning authority received a prior approval notification, it wasn't open to it to consider, well, whether it actually, was in the curtilage of a dwelling house, for example, for Class A or not. Rather, all it could do was consider the specific factors set out in the order. But then there has recently been a judgment of the Court of Appeal in Westminster City Council. You can see it listed on the slide there, sometimes known as New World Payphones, where the Court of Appeal considered Keenan and seemed to suggest that what Mrs. Justice Lang had understood Keenan to say wasn't in fact what it was saying. And this is the judgment I started reading earlier, but this is an extract from the judgment in that case. It says, on an application to an authority for a determination as to whether its prior approval is required, then the authority is bound to consider and determine whether the development otherwise falls within the definitional scope of the particular class of permitted development. So hopefully, if you follow what I was saying, that does sound quite different from what Mrs. Justice Lang said in Marshall. Actually suggests that when a local planning authority gets a prior approval notification, the first thing it should consider is, does this fall within the scope of the relevant class or permitted development right being relied upon. But that judgment, the judgment in Westminster, doesn't actually address Marshall. It doesn't specifically say Mrs. Justice Lang got it wrong, and it's still slightly unclear about what prevails, whether Marshall prevails or whether it has basically been overruled by Westminster City Council. So if you're a local planning authority, it's still a bit, it is still unclear what you need to do when faced with the prior approval notification. It's perhaps made slightly less clear by the fact that even after the Westminster City Council case came down, Mrs. Justice Lang handed down a further judgment in RSBS Developments, which doesn't refer to Westminster, but basically restates the rule which she set down in Marshall. So all I can say at the moment really is it's not clear, except that I understand there is, I think Andrew is currently dealing with a case that touches on this matter, so we may get some clarity soon. My personal view is that it's safer to assume that Marshall is no longer good law, and that local planning authorities should consider whether whether the development falls within the scope of the relevant right. It also, to me, seems to make more sense of the order as well. But as I said, it's not conclusively determined. But that's where I think we currently are with what can be considered at prior approval. The next issue, which has generated some case law recently, is about time limits. And again, as I'm sure many of you know, strict time limits apply to the determination of prior approval applications, and they're set out in the relevant conditions within the GPDO. I think it's usually 28 weeks or 28 days or 56 days, typically the time allowed. And where what those conditions also say is that where the local planning authority has not determined and notified the applicant of any determination within that time period, then that condition requiring prior approval will be considered to be met. So you can carry on without your prior approval. You can carry on and implement the permitted development right. Now, those time limits are quite strict, and so put a lot of pressure on local planning authorities to turn around applications. But there can be occasions where local planning authorities consider they need more information, and that might particularly be so if they have to consider, for example, whether the proposed development falls within the scope of the right, as I've just discussed. And so they're left often with a difficult choice about whether to simply refuse the application or to go back and request further information from the applicant. And they have to make sure that they do all of that before the clock runs out. Now, Article 7 of the Permitted Development Order, which you can see on the screen there, does provide local planning authorities with the ability to extend time by agreement in writing with the applicant. And the meaning of Article 7 was recently considered in a case called Gluck. And that made 3 points, which you can see I've set out in the slide there. The first is that ability to extend time applies equally to the time limit set out in Article 7A and Article 7B. And what I mean by that is that Article 7A deals with the time limits where they're specifically stated in the relevant parts of the order. And Article B says that where no time limit is specifically stated, then the time limit will be 8 weeks. And it was argued in Gluck that you could only extend time in one of those, I can't remember which one, in one of those situations, but not both. But the court found that, in fact, you can extend time in both of those scenarios. The second thing it found was that where the Article 7, because what it says is that that the extension of time must be agreed in writing. What that means is that you don't need a written agreement like a contract, for example, but it just needs to be an agreement which can be evidenced in writing. So you might reach the agreement, as I said on the slide there, orally, but you follow it up with an email confirming the agreement, and you don't necessarily need something in writing from both parties to evidence that agreement. And indeed, on the facts, just as an illustration, so in Gluck, the local authority's planning officer informed the developer's agent that his application would be rejected because they had concerns about noise from neighbouring premises. So a bit like the scenario I was painting earlier. The agent asked the planning officer to delay making the decision until the 12th of May, when the local authority's environmental protection officer could meet with the agent's acoustic surveyor. And what the planning officer did is he sent an email thanking the agent for his email, indicating that he'd discussed the matter with his manager, and that was it. He didn't follow up on that at all. Now, what happened is the time limit ran out. No prior approval determination was made to the developer wanted to proceed with the development, and asserted that there was no valid extension of time because there was no because the planning officer hadn't got back to him and agreed either way. The court disagreed. It found that the planning officer's email was enough to evidence an agreement in writing, or it was enough to evidence an agreement to extend time in that case. And it did advise planning officers to routinely follow up in writing and make sure that these agreements are evidenced in writing. And the third thing it said was that an extension of time can't be general in nature. So you can't just say, well, we'll extend it until we've dealt with this problem. You need to be able somehow to identify the length of time. So moving on, because I'm running out of time myself. Finally, this is a complicated issue, prior approval, challenging grants of prior approval. Recent judgments handed down in Coventry Gliding Club. I think rather than go through the facts, I'll say confirm 3 things. One, that if you're a third party and you don't agree with the grant of prior approval, then your only option is to bring a judicial review. What Coventry Gliding Club confirmed was, first of all, the 6-week time limit for general planning judicial reviews will apply. Second, that the strict time limits on determining prior approval applications are compatible with the human rights of third parties. So that they're right, that it was argued that because that it didn't allow third parties enough time to make representations effectively, but they found that wasn't a valid concern. And then finally, it raised a question about what happens where a grant of prior approval is quashed after the deadline for determining prior approval applications has expired. Because the issue you have is, if you have a grant of prior approval, it's challenged in judicial review, you go through the process, you win your judicial review, the effect of that will be that the prior approval grant is quashed. What the council, I think it was the local authority, argued in that case was that nevertheless, the effect of that means that no decision has been made on prior approval, and the time for doing so has expired, and therefore there's the prior approval condition should be deemed to have been fulfilled in any event. Now, if that's right, then clearly it would mean that there's little merit often in bringing a judicial review of grants of prior approval, because ultimately you gain nothing from doing that. Now, in Coventry Gliding Club, you do get that wasn't a main issue, so there was some obiter consideration of it. And what Mr. Justice Swift says is he doubted that was right, and he suggested that you might use Section 3 of the Human Rights Act in particular to effectively read that provision so that it allowed third parties with a realistic right to challenge grants of prior approval. But as I said, that's not determined. That's quite a tricky issue, but it's worth reading it's in a footnote to that judgment to see where the position is. Now, I've reached the end of my time. I'm just going to skip through the last couple of slides and tell you what they say. So you have Article 3.5 is about unlawful developments. In RSBS, what that effectively decided was that will apply throughout the course of your development. So say you get prior approval for something, you then carry out some unlawful development, and then on the basis of that, after that you then seek to implement your your permitted development right. Article 3.5 will still apply. So even after you've got prior approval, Article 3.5 will still apply. That's the basic point there, but you can read more on the slides and in the case. And then some further clarification on curtilage, which I won't read out, but if you thought curtilage couldn't get more complicated, it probably has a little bit. But if you read Mr. Justice Holgate's decision in Hampshire, it does provide quite a comprehensive survey of the relevant law and the relevant principles. And so that's it. Thank you very much for listening to me. I think Andrew's going to come in and hand over.
Thank you very much, Ben. You're quite right. The Marshall case is going to be considered shortly. The practical point that arises that will be interesting for local planning authorities is if you as a local planning authority cannot determine whether the definitional requirements are met at the prior notification stage, then really your remedy is to commence enforcement action in due course if somebody relies on the prior approval notice, which is procedurally more of a burden for local authorities, but that will be one of the issues to be determined. Can I introduce then Matthew, who's going to be doing our next talk on tricky issues or thorny issues in planning enforcement. Matthew has a wide planning and environmental law practice. His recent highlights including acting as sole counsel for Bolton Council on a call-in inquiry in relation to a proposed Ryder Cup golf course, and successfully defending Reading Council's refusal of permission for new student accommodation at the university. He writes for the Planning Encyclopedia, garners environmental law, and is the editor of the environment section of the civil court practice. Matthew, over to you.
Thank you, Andrew. Now, I'm going to touch on some thorny issues in planning enforcement. Obviously, don't really have time in my 15-minute slot to cover all the thorny issues that arise in planning enforcement. So I've focused on what I think of as the kind of middle phase of an enforcement inquiry. So after you have that, after officers go out and make their first investigations, have a look at the site, maybe send a planning contravention notice, And at that point where often legal and the planning enforcement team start to discuss how this breach, generally by that point there's a pretty clear idea that there is a breach, how that breach is going to be addressed. So I've looked at three groups of issues that arise. First, around the factual and legal issues that arise when defining the breach. Secondly, how to deal with alternative or fallback developments that the appellant or landowner at this point might be putting forwards. And then thirdly, we've had a couple of recent cases about declining to determine applications under section 70C. So I'll come on to that in due course. Area 1, defining the breach and requirements. Now, I mean, the first point, of course, is just to remember that the enforcement notice is subject to a number of statutory requirements. So as you go about thinking about crafting your enforcement notice, you need to be fully aware of those. And I'd flag that the RTI has quite a helpful handbook, which kind of lists each of the requirements in a perhaps more digestible way than just simply plowing backwards and forwards through the statute, which is what I tend to do. First point, obviously, fairly clear that the breach needs to be stated as the language of the statute, but needs to be described fully so that the recipient knows what the breach is. There is a point about you need to make sure that you identify whether this is a breach of a planning condition or a breach of planning control in its own right, what kind of planning control breach planning control you have. You need to give reasons, which I think good practice would suggest should state the immunity period that you think applies and why it's not met. Explain the harm that the unauthorised development gives rise to and why it's contrary to policy, and make clear whether the purpose of the notice is simply to remedy an injury to amenity or also to remedy the breach. And that can give rise to particular issues if ground F appeals are brought. So the general rule would be to make sure you draft your notice in such a way that remedying the breach is raised as well as any injury to amenity. You need to specify the requirements, what the enforcement notice is requiring the landowner to do. And I note there just the need for precision in defining your requirements. There is case law to emphasise that the word under the relevant subsection is specify, which is contrasted with just stating the allegation in subsection 1, the first subsection. Also need to give a date for taking effect and time for compliance, which I'm not going to deal with, and the various forms of additional information. Now, key issues that tend to arise, I've picked out two. One is the risks around under-enforcement, which I think is something that the legal teams particularly are often quite alive to. That arises because section 17311 gives a deemed planning permission for any works or activities which could have been specified, could have been required to be remedied by the notice, but were not. Now, that doesn't mean critically that all things that are thought to be unauthorised on the site in question need to be caught by the notice. The Fiddler case confirms that the effect of 17311 only extends to works or activities which form part of the breach of planning control alleged by the notice. So that has an interrelation, an interaction with what I think is often the main issue that local authorities are grappling with, which is whether and to what extent the various things that are going on the site form part of a material change of use, if indeed that's the kind of case you're looking at. If works are integral to the material change of use, then the notice can require their removal, even if they would otherwise, as a freestanding piece of operational development, be immune. That's the Murphy case, or indeed if they wouldn't be development at all. So in Somac Travel, there was a case about an internal staircase, and because it was internal, it wouldn't be operational development, but the notice could pick it up as part of the change of use of the premises as a whole. The wrinkle in that is that issues can arise if the works in question were undertaken prior to the material change of use, and could be, and were originally, used for a different lawful use. That's the Burring case, which relates to kitchens within a building which had been converted to an HMO, and the kitchens potentially had a different use, supporting the lawful dwelling house use of the site. That for a while was thought to create a tension, and there are certainly some comments in Burring which are difficult to reconcile with Murphy and Semakula. But for the purposes of authorities advising and dealing with issues today, it's important to note the Kestrel case, which looked at the case law, reaffirmed Murphy and Semakula travel, and critically was decided at the Court of Appeal level, so is definitive for our purposes at the moment. So a bit of an example to think about how these points interact. This is loosely based on the Murphy case. So imagine a farmyard that's being used for a plant hire and haulage business, and has been so used for 5 years prior to the putative notice. You've got a hard standing and a porter cabin on the site, both of which would potentially be operational development in their own right. The owner contends that the hard standing has only been around for 2 years, but that the porter cabin was brought onto the site 5 years ago. So let's say 6 years ago. I think I meant that to be before the farm business started, or the plant hire and haulage business started. So the porter cabin was brought in before that, for the intention, which was never actually carried out, of using it in relation to the farm business. So we've got a 4-year operational development time limit, which wouldn't catch the porter cabin, but the material change of use limit is 10 years. Things to be thinking about. First is that the porter cabin can't be enforced against as a standalone piece of operational development. So you're going to, if you want to get rid of it, if your officers want to get it off the site, you're going to need to be thinking about whether a proper argument can be raised, whether as a matter of judgment, the bringing the porter cabin on and siting it on the land was part and parcel or integral to the material change of use of the land to a haulage business. Now that is a factually complicated area. You'll need to get your evidence together. You'll need to see what evidence the officers can drag out and what the appellant says about how far the farm owner can go to substantiating this independent lawful use which they claim. If they can't, then it's likely that an inspector would take a fairly robust approach, I would expect, but that's going to be something to be discussed. As for the hard standing, again, you'll need to think about whether it's really part of the change. It might be said that it's referable to other farm uses going on in the locality, so you'll want to investigate that issue. And you'll also want to think about whether or not it's something that you want removed from a general management development perspective. Because if you don't remove it, then you're going to get into the under enforcement issue, where you might find that the owner of the land starts arguing, even if you took the view that the hard standing wasn't part of the material change of use, that he thinks it is, so it should have been enforced against, so it's now lawful. So these are the issues you'll need to work through, and they need to be dealt with quite carefully to make sure that your notice is focused on the matters that it needs to, and doesn't leave anything out that's going to give rise to an under enforcement argument. So that was my first kind of thorny, knotty area. Second, are alternative schemes of development. I mean, certainly in my experience, both acting for local authorities and occasionally for appellants or putative appellants, one of the main focuses in negotiations is to try and find an alternative form of development that might be acceptable. That's either in order to settle the matter properly, or, and local authorities will always need to be aware of this, it can be a sort of strategy on behalf of the landowner to bolster any ground A appeal by creating a fallback against which backdrop the impacts of this development can be said to be, the development enforced against, can be said to be lesser to bolster the case that planning permission should be granted. One option for the landowner is to apply for planning permission for whatever their alternative form of development is, and we'll deal with the circumstance in which that can be ignored, where the circumstance in which the local authority can decline to determine it under my issue 3. But if they don't make a separate freestanding planning application, then what are the opportunities for the alternative scheme to be considered on the appeal? Now, here it's important to first of all just bear in mind the scope of the inspector's powers on appeal, which are quite extensive. He or she may grant permission for the development enforced against. Obviously, that requires a ground A appeal, or any part of it, section 1771. And that sits alongside his power to vary the enforcement notice, which can allow some forms of halfway development to be granted. Now, always the scope of whether an inspector is going to be willing to consider these issues is defined by what grounds have been raised by the appellant. And to remind ourselves, ground A is the argument that permission should be granted for the matters alleged, and ground F is the argument that the steps required exceed what is necessary to remedy the purpose of the notice, and that will be either a breach of planning control, remedying the breach of planning control, or remedying harm to amenity, which is the point I mentioned earlier. So, key question is often going to be, does the alternative scheme form part of the development enforced against? And here, I think the really interesting, really useful case to have a think about is the case of Ahmed, which was in the Court of Appeal in 2014. Now there, it was a written reps application, and the Court of Appeal held that the inspector had erred in failing to consider whether a smaller 3-storey scheme could be permitted where a 4-storey scheme was enforced against. And the backdrop is that a 3-storey scheme had been granted permission, a 4-storey scheme had then been built, and although the appellant put his argument in terms of ground F, which wasn't possible, the inspector had, in the view of the Court of Appeal, failed to consider an obvious alternative. This is the take-crown line of authorities, which was partial grant of permission under ground A. So the inspector had failed to say to himself, what could the 3-storey scheme that was originally granted permission, could that be described as part of the development which had been now enforced against, in which case should I grant permission for it? Now, the availability of that route depends on the alternative being part of what has been done. And critically, in Ahmed, there was no decision from the Court of Appeal that a 3-storey would necessarily be part of the 4-storey. That was a matter of planning judgment, and the Court of Appeal's decision remitted that question back to the inspector. But you know, it is going to be an important issue for any inspector, so it's something the authority will need to consider when trying to decide whether to take enforcement action or responding to settlement proposals from the landowner. Ground F, I mean, this is a thorny issue. If you just have a ground F appeal, then you get into all sorts of complicated issues around the case law. Generally, these principles, I think, will guide you. If the alternative goes beyond what's been enforced against or doesn't form part of it, then it can't be granted under planning permission under ground A, so therefore can't be granted under ground F, and that's the Court of Appeal's decision in what Ioannou, which was a case about the subdivision of a flat, of a building which could be laid out as 5 flats, and there was a question whether it could be rearranged as 3, and that granted permission through the appeal. Further, ground F, if it's on its own and there's no ground A appeal, can only be used to argue for the survival of part of the development if the requirement which is said to be excessive, remembering that's the ground F appeal ground, is solely to remedy an injury to amenity. That's Miaris. So if it's clear, and this is a matter of construction for the inspector and potentially for the court, if it's clear that the real focus of or at least one of the focuses of the notice is remedying a breach of planning control, to which planning objections beyond just injury to amenity attach. So if your breach of planning control is harmful for policy reasons rather than because it gives rise to smells or noise or whatever your amenity issue might be, then ground F can't be used to seek a part survival of the development enforced against. It follows that in general there are quite limited bases for alternative schemes to be considered outside of ground A appeals. Turning now to my final point, this is declining to consider further applications under section 70C. Relatively new power provided under the Act, and it basically, I've set out the statute there. Local authority may decline to determine an application if granting permission for the development would involve granting, whether in relation to the whole or any part of the land to which the pre-existing enforcement notice relates, planning permission in respect to the whole or any part of the matters alleged in the notice. So the power allows local authorities to decline to determine applications where they overlap with a pre-existing enforcement notice. Relevant principles from the case law, and there's been quite a flurry of case law. The first case to note is the Wingrove case a few years ago, which stressed that the underlying purpose of the section is to prevent retrospective applications being used to delay enforcement action. We then had a more recent case, the Chesterton case, which emphasised that it can extend the power to refuse to consider the application, to decline to determine. That can extend even to cases where there are quite substantial differences between what's being proposed in the new application for planning permission and what has been built and enforced against. So there, the enforcement notice was against a building linking I think it was a garage and a boathouse, and presumably some hyper wealthy individual here. And the linking building was at ground level. That was enforced against them, and the application for permission looked to build a first floor link between the two. So it was a kind of balcony construction. That was held to be within the scope of sections 77C, 77C or 70C, I forget what our statutory 70C. But it's quite difficult to reconcile that case with the Bangor decision, which was just a year earlier, where it was emphasised that you shouldn't, as a local authority, be using section 70C to prevent consideration of effectively new matters. So in Bangor, the case was a situation where a building had been granted permission, construction of a building had been granted permission for storage purposes. It was then used as a dwelling house, and the application which the local authority refused to consider involved converting it back to its original intended purpose, storage. And the High Court said that it wasn't appropriate for the local authority to use its section 70C powers because there was no scope within any enforcement appeal to consider whether or not that could be permitted. So it was inappropriate. So careful in using section 70C. It does require some matters of judgment, and remember that the underlying purpose is to prevent repetitive and abusive reconsideration. It's not there to allow the authority to avoid a new matter, a new form of development being considered. So it will interrelate with the scope of what can be considered on the enforcement appeal. I think that completes my slides, and I will hand over to Joel, following I think Andrew's introduction. Thank you very much.
Thank you, Matthew, for that very helpful and interesting talk. I'll hand over to Joel quite quickly. Joel is going to be talking about some legal issues relating to planning conditions and legal obligations. Joel is one of our newest tenants and specialises in property planning and public law. He already has a lot of experience in advising local authorities, parish councils, campaign groups and individual objectives on a range of planning issues, and is particularly interested in environmental, DCO and infrastructure matters. Joel.
Hello, everybody. So there we are. So this is a whistle-stop tour through some of what I consider to be the most pressing issues affecting conditions and planning obligations today. We'll appreciate this is a wide topic, but we'll try to get through as much as we can in the time that we have. Of course, I've already gone too far on the slides. Let me see if I can take us back a slide. There we are. So the issue I want to start with is interpreting planning conditions. Now, the issue of proper interpretation of conditions and planning permissions has been dealt with in some detail at Supreme Court level in Trump and Lambeth. But more recently, Mrs. Justice Leven in UBB Waste Essex Limited and Essex County Council set out the key principles from those two cases and elaborated on some key points that I wish to emphasize. The first is, when interpreting a condition, the reasonable reader does not mean that they are the informed reader of a decision letter, but the reasonable reader is expected to understand the role of the permission, conditions, and any incorporated documents. Now, on the second and third points on the slide, references to common sense are really pointing to the planning purpose of the permission or condition. So if the interpretation advanced flies in the face of the purpose of the condition and the policies underlying it, then common sense may well indicate that that interpretation is incorrect. So if you remember Lambeth, that was about a condition to prevent the sale of food. In that case, the court determined it was plainly contrary to the relevant purpose for the permission not to limit the sale of food items. Finding that such an interpretation was contrary to common sense once one understood the planning background. On the fourth point, the starting point really should be the reasons for the condition, then looking at the policies referred to, and then finally considering documents incorporated. It's important to stress that we're not looking here at the private intentions of the parties like we might when we're interpreting a contract, but really trying to understand the planning purpose which lies behind the condition. On the fifth point relating to the relevant documents, now interpreting these documents can often be a difficult exercise, given, as we'll all be aware, they're often internally inconsistent and it's not uncommon to find some ambiguity. I think the sixth point here stresses that even where there is ambiguity in documents, there's a difference between documents which are in the public domain and easily accessible, such as the officer's report that led to the grant of permission, and private documents passing between the parties or their agents. In UBB, Mrs. Justice Leven reminds us that we should be slow to consider the intention alleged to be behind the condition from documents which are not incorporated, especially if not in the public domain. One practice point and a reminder is that it was determined in Newark and Sherwood District Council that the courts may resolve an apparent mistake in a planning condition by a process of construction. Moving on to conditions and new permissions. Now, just a quick reminder again about the case of Lambeth, which was heard in the Supreme Court in 2019. In that case, the Supreme Court were faced with interpreting a planning permission granted under Section 73 of the 1990 Act. The facts of that case it involved a home-based store which was granted planning permission in 1985. The Section 73 application was made in 2010 to allow for a greater range of goods to be sold from the premises, and permission was granted with the condition that there would be no sale of food. In 2014, a second Section 73 permission was granted. However, this did not allow, this did not include a condition restricting the sale of food. In that case, the Supreme Court held that the earlier conditions remained valid and binding because there was nothing in the new permission to affect their continued operation. Now, that's important for those of us here on this webinar because whilst a decision in Lambeth was decided on the specific facts, it does provide a greater scope for local planning authorities to argue that pre-existing conditions could continue to affect the relevant site. But when we're talking about obligations, the same is not necessarily true. And here I want to talk about a recent case of Mr. Justice Holgate, Norfolk Homes Limited and Norfolk District Council. In that case involved an affordable housing contribution, which was required under a planning agreement attached to the original consent for 85 homes. The High Court there determined that it did not apply to a subsequent Section 73 permission because it was not explicitly reiterated in the subsequent approval of revised conditions. There, the court rejected the attempt by the council to rely on an implied term. It concluded that the impact of such an implication would be extensive, capturing any variation to the development, requiring parties to expressly exclude Section 73 to avoid such an implication. This case provides a helpful confirmation of a helpful reminder to local planning authorities in particular that development undertaken pursuant to a Section 73 permission needs to be explicitly bound either by the original Section 106 agreement or by a new Section 106 agreement. I want to talk about amending planning obligations because the current economic situation is such that I would expect to see more applications to have planning obligations amended in order for developers to be relieved of certain obligations. As many will be aware, a planning obligation may be modified or discharged in one of two ways. The first is by agreement at any time. Now, this does require the consent of all persons against whom the obligation is enforceable. The second is pursuant to Section 106A of the 1990 Act. Now, under Section 106A(3), this allows any person against whom a planning obligation is enforceable to apply at any time after the expiry of the relevant period to the appropriate authority for the obligation to be modified or discharged. Importantly, this doesn't require the consent of all against whom that obligation could be enforced. The relevant period here is generally 5 years, but it can be some other agreed period. Just a reminder that in Bachelor, Mr. Justice Sullivan indicated that a local planning authority nonetheless has discretion to entertain an application to modify or discharge prior to the expiry of the 5-year period, and that an irrational failure to do so would be amenable to judicial review. Now, the operative test for a discharge of the obligation is whether the obligation serves a useful purpose, but this is not a high test. It doesn't necessarily mean useful planning purpose, nor must that purpose be related directly to the underlying development or its mitigation. Another practice point here is that in making its decision, the decision maker or local authority must identify the purpose that the obligation fulfills. And then it has 3 options. It can either refuse, discharge, or modify. Now, I quickly want to talk about the case of Garden and Leisure Group Limited. In that case, Mr. Justice Richards held that an application to modify an obligation was an all or nothing decision. It was not open to the authority to accept some of the proposed modifications and not others. If it found some of the proposed modifications unacceptable, it may invite the applicant to submit a fresh or amended application, but it must deal with the present application in its entirety. Now, the form of notice of an application under this section and the procedures governing its determination are prescribed by the Town and Country Planning Regulations 1992. And there's some very specific things that local authorities are expected to do. They're required to give publicity to the application by site notice. They cannot determine the application until the 21-day period allowed for representations to be made by third parties has elapsed. they're required to give written notification of their decision within 8 weeks, or some other period as may be agreed. And an adverse decision must be accompanied by a clear and precise statement of reasons, and inform the applicant of the right to appeal. And finally, I just want to quickly talk about section 106B, which states that an applicant may appeal to the Secretary of State against an adverse determination, or in the event that the authority fails to give notice of their determination within a period to be prescribed. The Secretary of State here has the same powers in dealing with an appeal as if the local authority had on the application, and that appeal is to be treated in the same way as an appeal against the refusal to grant a planning permission. Moving on now to unilateral obligations, and this is a case that much has already been written about, a case of Ikram, in which the Court of Appeal upheld the decision of the High Court, quashing the grant of planning permission by a planning inspector, notwithstanding a unilateral undertaking having been entered into by the landowner, whose intent was to cure the recognized defect in a condition to which the grant of permission had been made subject. Now, although a unilateral undertaking or a Section 106 agreement was in principle capable of curing a defect in the prior planning process, it failed to do so in this case because the error was so fundamental. Why do I think that case is important for all of you? Well, in this case, the Court of Appeal has made it clear that local planning authorities and indeed inspectors must carefully consider the conditions that are proposed to be attached to the grant of a planning permission. There has to be an intimate nexus between those conditions and the use or operational development for which planning permission was sought, and the way in which that application was assessed. This decision now makes it clear that any error in a condition and/or any failure to restrict the development, whether by change of use or by operational development, to that which was applied for and assessed, cannot necessarily be remedied by a post-decision Section 106 agreement or indeed a unilateral undertaking. A quick point on interpretation. Given what I've said, I would also like to make everyone aware of Aspire Luxury Homes, Eversley Limited and Hart District Council, which came out last year. This case made it clear that it was not an abusive process to bring an ordinary civil claim in relation to the construction of a Section 106 agreement. And there is a risk that those seeking to avoid obligations may consider this another potential line of attack. At this point, I'd now like to hand back to Andrew.
Thank you very much, Joel. We're running pretty well on time. We've got about 5 minutes for questions to take us to 12. We've had a small handful of questions come in, so we'll try to deal with them all. If you do need to get off now or by 12 o'clock, completely understand. Thank you very much for joining us. Just a reminder, there is a second webinar next Monday, the 15th of March at 11 AM, and that will focus on dealing with appeals. So please do join us for that session also. But in terms of the questions then, I'll take them in the order of the speakers. So Ben, first of all, a couple of questions came in on the Q&A, which would be helpful for you to think about. Well, the first of those was whether or not you consider that extending the list of, that's my timer, forgive me, to let Joel know that he's running out of time. The first of those was whether or not the panel think the list of prior approval options available just create greater confusion and applicants are just resorting to planning permissions anyway. And the second question, which you might as well deal with at the same time, is how local planning authorities should deal with past prior approval decisions, where no assessment of whether the definition requirements have been met has taken place. What should happen in that situation? Ben.
Thanks, Andrew. Yeah, I can deal with those. So on the first question, I do think it is problematic and it creates a lot of uncertainty. And there are two particular issues with it. I mean, the first is well, I suppose they're rolled up, but what standard are you assessing things like daylight against? And what's the role of local development plans even in the determination that you have to make. These are not planning applications, so they don't engage the same statutory duties under section 38(6), for example, to have regard to the development plan. Although I think it is valid to consider it as a material consideration in the right circumstances. But the same with the MPPF. So some of the conditions specifically require you to have regard to the MPPF as if you were determining a planning application, but they don't all. And what does that even mean, as if determining a planning application? There are problems with that as well, because of course you're not determining a planning application. Planning permission is granted, you're just determining it's a conditional issue that you're determining. And what about, for example, home conversion of a barn in the countryside? Now there might be planning policies, and the MPPF as well talks about avoiding isolated dwellings in the countryside. Well, is that relevant to the decision you have to make, or is it not? I mean, there's guidance that says that you shouldn't, because the GPDO considers that that's appropriate. It creates a lot of confusion, and I think there will be a lot of issues that come out of it. And linked to that point, aside from what policies you consider, what is adequate daylight? We don't know. There's no legal standard of daylight that's required, and by putting these in the GPDO, there's a risk that they make these into questions of law, which is almost impossible for a court to determine. So I think it has caused a lot of uncertainty, and the feedback that I've seen anyway so far is that people are just avoiding them and making planning applications, as suggested by the questioner. Yeah. That's my experience of it. So it is problematic.
And then that second question, Ben, about the past prior approval decisions, I touched on it briefly with the Marshall case, and the fact that one remedy at least was enforcement action in the future, which has its own problems. But was there anything else to add?
No, but I think it's just to stress that, as I said, Keenan makes very clear that granting prior approval is not a grant of planning permission. So you say you might have granted prior approval for development that actually turns out doesn't fall within the permitted development right. Well, you're not barred from that. Doesn't mean it's lawful development. So you can take enforcement action. That would be the option that you'd pursue in that situation, I think.
Thank you, Ben. Matt, a couple of questions as well for you. One of those came in actually before the seminar, which is quite helpful. And the question was along the lines of if there was an unauthorized hospitality use, which is temporarily ceased because of COVID, the lockdown restrictions. Can a local planning authority still issue an enforcement notice, or does it have to wait for the use to restart when the lockdown ceases? And there's a related point about the temporary cessation not counting towards the immunity period. Could you address that?
Oh, thanks, Andrew. The first thing is that I'm not aware of any statutory intervention on this issue. So we're applying the normal rules for looking at material change of use and interruptions, albeit in a very unusual circumstance, which obviously will have to be decided, how that work plays out in the courts in due course. I think here the test is going to be, if the property there has been an unauthorized change of use of that property to hospitality use, then unless there's been a further material change of use to something else, then I would have thought that there's likely to have been continuation. You'll have to look at the facts, but that would be my instinct. And I think it's just important here to remember that, much in the same way that a dwelling house can be enforced against without someone living there, a hospitality venue can be enforced against despite not holding any gigs. So if it can be, then time is running, and immunity is a risk if you don't take action during this time.
Yeah, no, thank you. And another question that came in was about how a fallback might be treated in a situation where a building is built but never used for its intended purpose. So could it be argued that there isn't actually a proper fallback if there was no apparent intention to use it for its original purpose? Yeah,
I think there are kind of two parts of this. Firstly, I think we need to remember that fallback properly is an argument that you make when you're trying to justify why something should be granted planning permission. And the argument is that if you compare what I'm asking for planning permission for now, the impacts of that, its compliance with policy. If you compare that to something else that the applicant can lawfully do and has a real prospect of doing, you say that it's actually got only minor additional impacts or it's better. So here, the fact that it hasn't been used in the past for its intended purpose is, I think, probably by the by, strictly in terms of whether it's a fallback. The question is going to be, well, what is the real prospect of it being used for in the future, and is that useful? Is it useful? Is that lawful? And would that be less or more harmful than whatever it is you're seeking to enforce against? I think that's going to be the real thrust of the analysis. And as to whether it's best to enforce against the building or the material change of use, I think that is going to depend on the facts and whether you think it's part and parcel of the material change of use.
Yeah, and eventually, ultimately as well, what can be evidenced? If there was never an intention to use it, that's going to be a relevant factor to take into account.
Absolutely. All of these issues, you're going to have to. They're always good. There's good scope for backwards and forwards between the planning enforcement team and the legal department when you come to these matters. I think it's a discussion.
Yes. Yeah. Okay. And then final question, Joel. This one from me. You mentioned Aspire luxury homes case, which determined it was not an abusive process to bring an ordinary civil claim in relation to the construction of a Section 106 agreement, which seems to me to be pretty commonsensical. But what do you expect to be the practical implications of that judgment?
Look, I think it's likely to prompt developers in particular and others considering bringing an ordinary claim against a local planning authority where there is a dispute concerning the construction of a Section 106 agreement, just to really think hard about which of these two options they wish to pursue. I think if they're deciding whether to bring an ordinary claim instead of or in addition to, say, a planning appeal, claimants there will still need to consider a number of factors, including looking at the particular issues in dispute, the relevant timescales, whether it would be preferable for a judge or a planning inspector to determine the matter, whether actually there are damages, whether damages are sought, and any particular costs, risks. So I think those are the type of things that people are likely to consider. And to me, it just looks like another potential line of attack that local authorities may need to be aware of.
Yeah. Thank you, Joel. Well, those are our questions. So it just falls to me to thank you all for watching today and for the questions. We really appreciate the large numbers of people that have turned out to watch and to listen. We hope you found it useful. And just a reminder again that this is the first of 3 sessions, and the second of those will take place next Monday, and that's dealing with planning appeals. Hope you can attend that session also. Thank you very much, everybody. Have a good day.